Here is one rather common scenario in disability discrimination cases and one common strategic mistake that you should avoid if you're a claimant in such a case. So here's this common situation. Let's say you worked at a company and you had a serious conflict with your manager. As a result of that conflict, you've developed and you've actually been diagnosed by a doctor with a serious psychological or psychiatric condition, such as anxiety, depression, PTSD, etc. All of those conditions are considered to be qualifying disabilities under ADA and California FEHA, Fair Employment and Housing Act. Eventually, you've been terminated, and you believe you've been terminated illegally because of your disability. One situation could be where you requested an accommodation or you requested for a certain amount of time off for medical leave. Your employer told you that they cannot accommodate you, they cannot grant you that leave, and they terminated you. In that type of case, in that type of scenario, it would be a mistake for you to focus on the nature and the substance of the conflict between you and the manager that led to your symptoms, that led to your disability, and led to your termination. In that type of case, it would be a mistake for you to go back and forth and argue and belabor who was right and who was wrong in that conflict, whether your boss was fair or unfair, whether you were fair or unfair. Remember, you're supposed to prove not who was right and who was wrong in that conflict. You're supposed to prove whether you were terminated illegally and whether your disability rights were violated. So the key questions are, were you diagnosed with a condition that's considered to be a disability? Did you notify your employer of your disability before you were fired? Did you correctly request an accommodation? Did the employer violate the law by not considering your request or by not offering something else? Was the reason that given to you by the employer for your termination, was that an actual true reason, or was it a false reason and a pretext for discrimination? Those are the issues that you should be focusing when proving your case through discovery, through depositions, through everything else. When you focus on the conflict, on what led to your symptoms, you're wasting time, you're wasting your energy, you're wasting your emotional energy, and you're also running the risk of basically admitting that the real reason for your termination is not your disability, but that conflict. And if that's the real reason, if the conflict is the real reason, and you're an at-will employee, then it wouldn't be illegal at all, because, as you may know, an at-will employee can be terminated for any reason or no reason, fair or unfair, except for discriminatory and retaliatory reason. So if you've been terminated because of that conflict, regardless of who was right and who was wrong, that wouldn't be illegal. So, to summarize, in that type of disability discrimination and wrongful termination case, you should not be focusing very much or at all on the substance of the conflict that you had between you and the manager. You should be focusing on the subsequent events, your symptoms, your disability, your request for accommodations, how you were terminated, when you were terminated, and what the true reason for your termination is. Thank you.